The first thing I noticed wasn't the white HOA SUV parked sideways across my gravel driveway. It was the chain. A heavy steel chain stretched across the entrance to my property, secured with a brand new padlock that definitely hadn't been there when I'd left for town an hour earlier. I eased my pickup to a stop, staring through the windshield as three people in matching navy polo shirts stood inside my own front gate like they owned the place. One carried a clipboard, another held a camera, snapping pictures of my workshop, my barn, even my American flag fluttering from the porch. The woman in the center folded her arms the moment I stepped out. "There he is," she said loudly enough for everyone to hear. Neighbors had already gathered along the road. Some watched from golf carts. Others stood in perfectly landscaped yards, phones already recording. The woman walked toward the gate with practiced confidence. "I'm Melissa Harper, Compliance Director for Willow Creek Estates HOA. She held up a laminated badge as though that settled everything. "We've documented multiple covenant violations. We've attempted contact several times. Since you refused to cooperate, we're conducting a mandatory property inspection." I looked at the chain, then at the padlock, then back at her. "You chained my driveway." "It was necessary," she replied calmly. "This property is under HOA authority." I actually laughed. Not because it was funny, because I'd never heard anything so absurd. "You need to remove that chain." She smiled the kind of smile people wear when they're convinced they're untouchable. "Not until the inspection is complete." One of the men beside her lifted a clipboard. "Sir, we've already cited you for an unauthorized workshop, agricultural equipment visible from neighboring lots, commercial vehicle parking, improper fencing, and failure to maintain approved landscaping." I blinked. "My workshop? Yes. My tractor? Correct. My fence? Also in violation." I pointed toward the weathered red barn behind my house. "My grandfather built that barn in 1952. Melissa barely looked. "The architectural committee never approved it." Several neighbors nodded as if that somehow made sense. I felt my pulse slow instead of speed up. That always happened when people became too confident in a lie. "You've made a very expensive mistake," I said quietly. Melissa stepped even closer. "No, Mr. Carter." She pronounced my last name like she'd practiced it. "The mistake was believing you could ignore the governing documents." One of her officers slipped through my gate, carrying a measuring wheel. Another headed toward my detached garage. Neither had permission. "Stop!" Neither one listened. I said stop. Melissa raised a hand without turning around. "Continue documenting everything." The man with the camera aimed his lens directly at me. "Hostile homeowner refusing compliance," he muttered while recording. That was enough. I pulled my phone from my pocket. Melissa smirked. "Calling your attorney?" "No." "The sheriff?" "No." She crossed her arms again. "Then who?" I looked directly into her eyes. "The county assessor." Several people laughed. Even one of the neighbors shook his head. Melissa's smile grew wider. "I don't think the county assessor is going to save you." "They're not." I scrolled through my contacts without rushing. "They're going to save you." Her smile faded just enough for me to notice. "What does that mean?" "It means," I said, "before another person takes a single step onto my land, I want the county to confirm something in front of every camera that's recording today." She tilted her head. "And what's that?" I locked my phone and slipped it back into my pocket. "That this property has never been part of Willow Creek Estates." Silence. Only the wind moved. Melissa recovered almost instantly. "That's impossible." "Is it?" "Our legal department verified everything. I'd asked them for a refund." She pointed toward my porch. "Finish the inspection." The officer with the measuring wheel took another step toward my garage. Before his boot could touch the concrete, 2 county vehicles turned onto the road behind my truck. Melissa smiled again. "You actually called them?" "I did." She looked completely relaxed. "I hope you're ready to be embarrassed." I watched the county survey supervisor climb out of his truck, carrying a thick, weatherproof folder. The moment he looked at my address, his expression changed. He stopped walking, looked from the folder to Melissa, then back at me. Finally, he spoke 6 words that caused every conversation on the street to die instantly. "Who told you this land has an HOA?" The silence that followed the survey supervisor's question felt heavier than the steel chain still stretched across my driveway. Nobody spoke. Melissa Harper's confident posture stiffened just enough for me to notice. One of the officers holding a clipboard slowly lowered it, looking from Melissa to the county employee, as if waiting for someone to explain the obvious. The survey supervisor didn't repeat himself. Instead, he looked directly at me. "Mr. Ethan Carter." "That's me." He nodded once. I figured. Then he glanced toward the chain blocking my entrance. "Mind telling me why HOA officers have your property locked?" I was hoping you could answer that. A few neighbors exchanged confused looks. They'd shown up expecting another homeowner being disciplined by the association. Instead, the county's senior survey supervisor looked genuinely puzzled. Melissa recovered first. "Our legal department has already verified this parcel belongs within Willow Creek Estates." The supervisor frowned. "Which parcel number?" She hesitated. One of her officers quickly flipped through a binder before reading off a number. The supervisor didn't even open his folder. "That's not this property." A murmur rolled through the crowd. Melissa forced a smile. "There must be some misunderstanding." "Maybe," he looked at me again. "But I've worked this district for 22 years, and I don't remember this address ever being inside your subdivision." I said nothing. Sometimes silence speaks louder than an argument. People assume land is just dirt, something you buy, something you sell. For me, it had never been that simple. My name is Ethan Carter. I'm 46 years old, and I own Carter Land and Survey Consulting, a small business that spends most days settling boundary disputes, reviewing easements, and helping families understand what they actually own before expensive mistakes happen. Ironically, the one property I never imagined I'd have to defend was my own. My grandfather, Samuel Carter, bought these 32 acres in 1951. Back then, there wasn't a subdivision for miles, no gated entrances, no decorative fountains, no neighborhood newsletters telling people what color their mailbox should be. Just rolling Tennessee farmland outside Franklin, where neighbors measured character by handshakes instead of committee meetings. My father was born in the farmhouse that still stood behind me. So was I. Every scar on the oak floors had a story. Every fence post had been set by someone in my family. The workshop the HOA called unauthorized. I'd built it with my father after high school. The old red barn? My grandfather raised it board by board after returning from Korea. Even the giant white oak beside the porch carried memories. My mother used to hang a tire swing from its strongest limb. Years after she passed away, I couldn't bring myself to remove it. Some mornings I'd sit on the porch with coffee before sunrise, listening to birds instead of traffic. No luxury mansion, no million-dollar estate, just a place where generations of my family had lived honest lives. That land wasn't valuable because of market prices. It was valuable because every acre carried someone's memory. Everything stayed peaceful until about 3 years earlier. That was when bulldozers arrived beyond my western fence. The old Jenkins farm had finally been sold. Within weeks, construction crews cleared hundreds of acres. Trees disappeared. Creeks were rerouted. Fields became paved streets. Then came rows of identical homes with gray roofs, decorative stone mailboxes, and perfectly measured lawns. A massive stone monument appeared beside the highway. Willow Creek Estates. Luxury living, private community, resort amenities. Soon afterward came the clubhouse, swimming pool, fitness center, walking trails, security gate. The development grew so quickly, it almost looked like a small city. At first, I figured we'd simply become neighbors. I had no reason to think otherwise. Developers build, people move in, life goes on. Or so I thought. The first strange sign seemed harmless. One Saturday morning, I found tiny orange survey flags pushed into my pasture, not near the property line, 20 feet inside my fence. I assumed a contractor had made a mistake. I pulled them out. The following week, more appeared, this time with white paint sprayed onto several of my fence posts. I called the developer's office. The receptionist apologized, said she'd look into it. Nothing else happened. A month later, landscaping crews accidentally mowed nearly 30 feet into my field. Again, they apologized. Again, I let it go. Then strangers began walking across my property. Some treated my pond like a neighborhood park. Others walked dogs through my pasture. One family even stopped to take pictures beside my barn. Whenever I'd politely explain it was private property, almost everyone apologized. Almost. One afternoon, A man jogging through my field actually laughed. "Relax," he said. "The HOA owns all the common areas." "This isn't a common area." He pointed toward the subdivision. "It's all Willow Creek." "No," I replied, "it isn't." He shrugged and kept jogging. That conversation stayed with me, not because of him, because he genuinely believed it. As the months passed, more residents acted the same way. Children rode bicycles down my gravel driveway. Delivery drivers left packages at my porch that belonged inside the subdivision. Real estate agents occasionally parked beside my barn while showing homes. Little mistakes. Individually meaningless. Together, they felt like pieces of a much larger misunderstanding. Then one Tuesday afternoon, I opened my mailbox and found an official-looking envelope with the Willow Creek Estates HOA logo. Inside was an invoice demanding $8,475 in unpaid HOA assessments. Dating back nearly 3 years, at first I honestly thought someone had delivered it to the wrong address. Then I looked closer. My name, my address, my property. That's when I realized this wasn't a simple mistake. Someone actually believed my family's land belonged to them. I stood in my kitchen for a long time, turning the HOA invoice over in my hands. The paper itself wasn't remarkable. Professional letterhead, barcode, payment instructions, a bold red notice across the top that read, "Final demand before legal enforcement." What caught my attention wasn't the amount, it was the confidence. Whoever drafted that letter wasn't guessing. They genuinely believed they had authority over property my family had owned for 75 years. I read every line twice. According to the notice, I owed nearly $8,500 in unpaid assessments, late fees, architectural violations, landscaping fines, and administrative enforcement costs. If payment wasn't received within 14 days, additional fines would accrue at $100 per day, and the association reserved the right to pursue legal action and place a lien on my property. A lien on land my grandfather purchased decades before Willow Creek Estates even existed. I laughed once. Then I drove straight to the HOA office. Willow Creek's clubhouse looked more like a luxury hotel than a neighborhood office. Stone columns framed the entrance, fresh flowers lined the walkways. A fountain sprayed water into a perfectly round pond, while soft music played through hidden speakers. Inside, everything smelled like expensive furniture polish. A young receptionist smiled. "Welcome to Willow Creek Estates." I placed the invoice on her desk. "I need to speak with whoever signed this." She glanced at it. "Oh, that's compliance. I'll wait." A few minutes later, Melissa Harper walked into the lobby, carrying a tablet. She recognized me immediately. "Mr. Carter, you know my name." "Of course." She smiled politely, but it never reached her eyes. "What can I help you with?" I held up the invoice. "You can explain why you're billing me for an HOA I don't belong to." She barely looked at the paper. "According to our records, your parcel is subject to the declaration of covenants." "It isn't." "It is." "No." "Yes." Her tone never changed. Calm, practiced, as though she'd had this conversation dozens of times. "I've reviewed my deed," I said. "So have we." "I've reviewed the county plat." "So has our attorney." "There are no HOA restrictions." "There are." I leaned slightly closer. "Melissa, have you personally read my deed?" She hesitated. "Our legal department has." "That's not what I asked." Silence. Finally she answered, "No." "I thought so." She folded her arms. "Our attorney confirmed your property falls within Phase 1 of Willow Creek Estates. My property existed 38 years before Phase 1. Our documents disagree." I stared at her for several seconds. Then I asked the question that changed her expression. "What document actually added my land to your HOA?" For the first time, she didn't answer immediately. Instead, she glanced toward another office. Just for a second, but I noticed. "So," I said quietly, "you don't know. Our attorney has all necessary documentation." "Then show it to me." "I'm not authorized to release legal files." "Convenient." Her smile returned. If you disagree with the assessment, you may file an appeal before the Architectural Review Committee. I almost laughed again. I don't appeal to organizations that have no authority over me. You don't have that choice. I absolutely do. No, Mr. Carter. She slid another packet across the counter. If payment isn't received, enforcement will continue. It did, faster than I imagined. Within a week, violation notices began appearing on my gate. Unauthorized barn, improper fencing, commercial equipment, livestock nuisance, unapproved exterior paint, failure to maintain community standards. It became almost comical. The barn they'd cited was older than most of the people writing the violations. Then contractors showed up. One morning I found landscaping flags, marking where they intended to extend a walking trail across the edge of my pasture. Another afternoon, a survey crew attempted to enter through my side gate. When I asked who hired them, one of the workers casually replied, "The HOA." I escorted them back to the road, politely, but firmly. The situation escalated again 3 days later. I was repairing a section of fence when a white security SUV stopped outside my property. A uniformed private security officer stepped out. "Sir, I'm here to investigate reports that you're interfering with HOA contractors. They're trespassing. They're performing authorized work. On whose authority?" "The association's." I pointed toward the county property marker embedded in the ground beside my fence. "That marker says otherwise." He looked at it, then at me, then back at his paperwork. "I've been instructed to advise you that obstructing HOA operations could result in law enforcement involvement." I couldn't believe what I was hearing. "You want the sheriff called because I won't let strangers onto my own land?" "I'm just delivering the notice." "Then deliver one back." "What notice?" I stepped closer. "The next person who crosses my fence without permission will be reported for criminal trespass." His confidence weakened. "I'll relay that." 2 mornings later, just after sunrise, I heard tires on my gravel driveway. Not one vehicle, 3. I looked through the front window. Melissa Harper, 2 compliance officers, and a county sheriff's deputy. The deputy knocked first. When I opened the door, he removed his sunglasses. "Morning, sir." "Morning, deputy." Melissa stepped forward before he could continue. "We're here to conduct a compliance inspection." The deputy immediately looked uncomfortable. "I haven't agreed to that," I said. Melissa held up another folder. "You've left us no alternative." I looked directly at the deputy. "Am I legally required to let them onto my property?" He paused, long enough to make Melissa visibly tense. Finally, he answered carefully, "I'm here to keep the peace, sir. I'm not here to force entry unless there's a court order." Melissa's head snapped toward him. "There doesn't need to be one." The deputy frowned. "There usually does." For the first time, I saw uncertainty spread across Melissa's face. But instead of backing down, she did something that told me this fight was far bigger than unpaid HOA dues. She reached into her folder, pulled out a document, and said the words that made my stomach tighten. "Then perhaps this county map will convince everyone that your property has belonged to Willow Creek Estates all along." Melissa Harper held the folded county map in the air, like she'd just pulled the winning lottery ticket. "There," she said, looking first at the deputy and then at me. "This settles it." The sheriff's deputy accepted the document. He studied it for nearly 30 seconds without saying a word. I watched his eyes move across the page. Then I noticed something. His eyebrows pulled together. Not in agreement, in confusion. He flipped the map over, looked at the front again, then handed it back to Melissa. "Where did this come from?" "Our legal department." "No," he said calmly. "I asked where it came from." "It's a county parcel map." He shook his head. "It doesn't look like one." Melissa's confidence flickered for only a moment before returning. "Deputy, regardless of your opinion, this property falls within our recorded subdivision." The deputy turned toward me. "Mr. Carter?" "I'd like to see the document." Melissa hesitated. Then, almost reluctantly, she handed it over. The moment I unfolded it, something felt wrong. Not because of what it showed, because of what it didn't. I spent 23 years reviewing plats, easements, subdivision filings, and boundary surveys. You develop instincts after seeing thousands of official documents. This one lacked several things every authentic county map contained. No recorder's stamp, no filing reference, no survey certification, no plat cabinet number. Even the font looked off. I looked at the bottom corner. There it was, a tiny notation, illustrative exhibit. Not an official map, an illustration. Someone had enlarged it, cropped out the disclaimer, and presented it as if it were an official county record. I looked back at Melissa. Did your attorney tell you this was legally recorded? It reflects the subdivision boundaries. That's not what I asked. She crossed her arms. It accurately represents the development. No, I tapped the lower corner. It represents someone's opinion. The deputy leaned over my shoulder. When he saw the tiny notation, his expression changed immediately. Melissa noticed. What? I handed the paper back. Deputy, that's not a county plat. He looked at Melissa. Ma'am, do you have an actual recorded subdivision map? She opened her mouth, closed it, then answered carefully. Our attorney maintains those records. The deputy nodded once. I think I'll wait until I see the recorded documents. For the first time since this nightmare began, Melissa looked genuinely rattled. She gathered her papers without another word. We'll continue this later. As the three vehicles pulled away, I stood in my driveway watching the dust settle. Something wasn't adding up. This wasn't simple incompetence anymore. Someone had gone through considerable effort to make my property appear inside the subdivision. People don't do that by accident. That afternoon, I called the one person I trusted more than anyone when property records became complicated. Rebecca Lawson. We'd known each other for nearly 15 years. Before opening her own law practice in Franklin, she'd spent a decade representing county governments in land use disputes. If anyone understood Tennessee property law better than Rebecca, I'd never met them. She listened without interrupting while I explained everything. The invoices, the inspections, the chain across my driveway, the fake map. When I finished, there was silence. Finally, she spoke. Ethan. Yeah? Bring every document you have. You think this is serious? I think someone is either making an extraordinary mistake, she paused, or committing fraud. Those words echoed in my head the entire drive to her office. Rebecca spread every document across her conference table. The HOA invoices, violation notices, photographs, the so-called county map. She examined each one methodically, making handwritten notes in the margins. After nearly an hour, she leaned back. I see 3 immediate problems. Only 3? She smiled. For them, she pointed to the first invoice. They've cited covenants that don't exist in your deed. Then another document. They've listed a subdivision phase recorded in 2018. My property predates it. Exactly. She flipped open a thick volume of county plats she'd borrowed from the courthouse archives. This is where things become interesting. She placed 2 maps side by side. One was the official recorded subdivision plat. The other was the HOA's illustration. At first glance, they looked almost identical, until she traced the western boundary with her finger. See this? I leaned closer. The official plat stops here. She tapped the edge of Willow Creek Estates. The illustration extends another 300 feet, directly across my land. I felt my stomach tighten. They expanded the boundary. On paper. But not legally. Rebecca nodded. Exactly. She circled the discrepancy with a red pen. This isn't a surveying error. It's intentional. Over the next several days, we dug deeper. We visited the county recorder's office, requested archived subdivision applications, pulled tax parcel histories dating back 70 years. Every document told the same story. My 32 acres had never been conveyed, never subdivided, never annexed, never subjected to HOA covenants. The chain of title was remarkably clean. Generation after generation, one Carter to another, nothing else. Rebecca also interviewed 2 retired county employees. One had worked in planning for 35 years. The other had reviewed subdivision applications before retiring. Both independently confirmed the same thing. That farm was always excluded. One even laughed. Developers asked about buying it more than once. What happened? The Carter family always said no. Then we found something neither of us expected. Hidden inside a planning commission archive was a development proposal rejected nearly 6 years earlier. It contained handwritten notes, meeting minutes, and an early master plan for Willow Creek Estates. Rebecca slowly slid the oversized drawing across the table. I immediately recognized my property. It wasn't inside the subdivision, it was sitting right in the middle of it. The original design had wrapped roads around my land because I had refused to sell. Then I noticed a handwritten note in blue ink beside the western entrance. It wasn't signed, just initialed. The sentence was only 9 words long, but it changed everything. Acquire Carter parcel later through administrative correction if necessary. I read the handwritten note 3 times before I trusted my own eyes. Acquire Carter parcel later through administrative correction if necessary. The room went quiet. Rebecca Lawson didn't say a word at first. She simply adjusted her glasses, picked up the planning file, and examined the handwriting under the conference room light. Finally, she looked at me. This, she paused, isn't just about HOA dues anymore. I leaned back in my chair. What exactly does administrative correction even mean? In legitimate land development, she shook her head, it usually means correcting a clerical mistake, a typo, a misplaced lot number, something harmless. She tapped the handwritten note with her pen. But that's not what this says. What does it say to you? It says someone expected your property to become part of the subdivision eventually, even though you never agreed to sell it. I stared at the old planning documents spread across the table. The note wasn't part of any official resolution. It wasn't signed by the county. It wasn't approved by the planning commission. It was someone's private instruction. Yet somehow, years later, Willow Creek Estates was acting as though that instruction had become reality. Rebecca carefully slipped the original file into a protective folder. We need to know who wrote this. The answer came sooner than either of us expected. Rebecca filed a formal records request for every version of Willow Creek Estates development application, including internal correspondence submitted to the county. 3 days later, the planning office called. The clerk sounded uneasy. Ms. Lawson, we found something else. Within an hour, we were sitting in the county archives. A records technician wheeled out 3 large storage boxes labeled Willow Creek Estates, Phases 1 through 4. Most of the contents were routine: engineering reports, traffic studies, drainage plans, environmental approvals. Then the technician opened a smaller envelope that had been clipped to the back of one file. There wasn't supposed to be personal correspondence mixed in here, she said. Rebecca carefully unfolded the papers. The first was an email chain. The second was a meeting agenda. The third stopped both of us cold. It was a letter from the original developer to the HOA's first board president. One paragraph had been highlighted years ago. The Carter parcel remains outside the recorded subdivision boundaries. Any future acquisition must occur through voluntary purchase or lawful condemnation. The homeowners association shall have no authority over the parcel unless ownership is legally transferred. Rebecca slowly lowered the letter. Well, she smiled for the first time in weeks. They just destroyed their own case. I felt the tension in my shoulders ease for the first time since this nightmare had begun. The original developer had admitted, clearly in writing, that my property wasn't part of Willow Creek Estates. Not only that, but he had warned the HOA they had no authority over it. There was no ambiguity, no confusing legal language, no room for interpretation. Word traveled faster than I expected. Apparently, someone at the courthouse mentioned that Rebecca had uncovered significant records. 2 days later, my phone rang. The caller ID displayed Willow Creek Estates HOA. I answered. Dr. Carter, Melissa Harper. Her voice was noticeably softer than before. "We'd like to discuss a possible resolution. I thought your documents already proved everything." A long silence. "There may have been misunderstandings. I don't misunderstand trespassing. We're prepared to waive all outstanding assessments. I don't owe any. And remove every violation. They were never valid." Another pause. "What exactly do you want, Mr. Carter?" I looked out the window toward the old barn. "I want you off my land." The line went silent. Then she tried a different approach. "We don't need to involve the courts. You should have thought about that before chaining my driveway." She exhaled slowly. "Our attorney believes litigation would be expensive for everyone. I'm counting on it." I ended the call. The next morning, the retaliation began. Someone posted photographs of my property on the HOA's private community website. The caption read, "Unsafe neighbor refuses community standards." Within hours, edited clips from the confrontation outside my gate appeared on local social media pages. The videos conveniently began after Melissa claimed HOA authority. They didn't show her officers entering my property. They didn't show the chain. They didn't show the deputy questioning her documents. Only me standing at the gate saying, "You're not coming onto my land." Comments poured in. "Arrogant. Probably hiding code violations. Nobody's above the rules." Some residents even drove past my house just to stare. A few slowed down to record videos from the road. One afternoon, someone threw an anonymous letter into my mailbox. It contained only one sentence. "People who fight Willow Creek always regret it." No signature, no return address. Rebecca read it and immediately photographed the envelope. "Save everything," she said. "They're building a harassment record." The pressure intensified. Survey stakes mysteriously appeared inside my pasture again. Unknown trucks parked near my entrance at night. A drone hovered over my barn one evening until I walked outside with binoculars. Then came the final surprise. Rebecca called just before dinner. "They filed first." "What?" "The HOA filed a lawsuit this afternoon." My stomach dropped. "For unpaid dues?" "No." Her voice hardened. "They're asking the court to declare your property legally subject to the HOA." I looked across my family farm, the porch, the workshop, the barn my grandfather built with his own hands. They weren't trying to collect money anymore. They were trying to rewrite history. Rebecca didn't sound worried. In fact, she sounded almost eager. "Good." "Good?" "They've officially put their claims under oath." "What does that mean?" She smiled. "It means every false document, every witness, every statement they make can now be examined in court." I looked at the thick evidence binder sitting on my dining table. The fake map, the archived planning notes, the developer's letter, the county records, everything. Rebecca closed the conversation with quiet confidence. "Get some rest, Ethan. You think we're ready?" "No." She paused just long enough to make me smile. "I think they're walking into the biggest mistake of their lives." The trial date was set for 6 weeks later. For the first time since this ordeal began, I wasn't wondering if we'd end up in court. I was wondering how many people were about to discover that Willow Creek Estates had built its entire case on a lie. 6 weeks disappeared faster than I expected. By the morning of the hearing, the Williamson County Courthouse buzzed with more people than I'd ever seen for a property dispute. Word had spread. A local newspaper reporter stood outside, interviewing residents. A regional television crew had parked a satellite van across the street. Even homeowners from Willow Creek Estates filled nearly every seat in the courtroom gallery. Some stared at me with curiosity. Others looked annoyed, as though I had somehow inconvenienced them by refusing to surrender my family's land. Rebecca Lawson adjusted the stack of binders on our table. "Remember," she said quietly, "don't react to their performance." "You expecting one?" She glanced toward the opposite table. "I'd be disappointed if I didn't get one." Right on cue, Melissa Harper entered with the HOA president, Daniel Brooks, and their attorney, Richard Harlan. Harlan carried himself like someone accustomed to winning. Perfectly tailored navy suit, expensive briefcase, confident smile. He shook hands with several people before taking his seat. Then he looked across the courtroom at me. "Mr. Carter, Mr. Harlan, I hope we can resolve this professionally, Rebecca answered before I could. That opportunity ended when your clients changed my client's driveway. His smile faded. We'll let the evidence decide. Exactly, Rebecca replied. At precisely 9 o'clock, the courtroom deputy announced, All rise. Judge Margaret Holloway entered with calm authority. She had served on the county bench for nearly 15 years and had a reputation for cutting through theatrics faster than anyone. After reviewing the filings, she looked over her glasses. Counsel, my understanding is that the central issue is whether Mr. Carter's property is legally subject to the Willow Creek Estates Homeowners Association. Yes, Your Honor, both attorneys answered. Very well, she folded her hands. Proceed. Attorney Richard Harlan stood first. He moved confidently before the judge. Your Honor, this is an unfortunate misunderstanding that has escalated unnecessarily. Rebecca quietly wrote something on her legal pad. Harlan continued. The association has maintained the Carter parcel for years as part of the greater Willow Creek development. I nearly laughed. Maintained? They had never mowed my grass, never repaired my fences, never paid my taxes. The governing documents, Harlan continued, clearly demonstrate the developer intended this parcel to benefit from and participate in the subdivision. He displayed enlarged neighborhood maps on a courtroom monitor. From a distance, they looked convincing. Roads, lots, walking trails, property outlines. He pointed toward my land. As shown here, Mr. Carter's parcel functions as an integrated component of Willow Creek Estates. Rebecca remained completely still. No objections, no interruptions. She simply waited. After 30 minutes of presentations, Harlan called his first witness, Melissa Harper. She walked confidently to the witness stand and took the oath. Under direct examination, she spoke smoothly. The association acted in good faith. We believed the property belonged within our jurisdiction. We relied upon legal advice. We simply attempted routine covenant enforcement. Then Harlan asked the question everyone expected. Ms. Harper, did you knowingly attempt to exercise authority over property outside the association? No. Did you believe the Carter property belonged to Willow Creek Estates? Absolutely. And did all of your actions reflect that belief? They did. Harlan smiled. No further questions. Rebecca stood. She approached the witness stand carrying only a thin folder instead of the massive binders stacked on our table. Good morning, Ms. Harper. Good morning. You testified that you personally believed Mr. Carter's property belonged to the HOA. Correct, Rebecca nodded. I'd like to discuss your records. Melissa smiled confidently. Certainly. Rebecca held up a single violation notice. You signed this? Yes. It states, Mr. Carter's barn violated architectural standards. Correct. When was the barn built? I don't know. Rebecca turned toward the judge. County tax records indicate 1952. She looked back at Melissa. When was Willow Creek Estates created? Melissa hesitated. Approximately 2018. So your testimony is that the HOA expected approval for a structure constructed 66 years before the HOA existed. A few people in the gallery chuckled. Melissa shifted in her seat. It was simply part of our compliance review. Rebecca nodded. Let's continue. She displayed another document. This map was presented to the sheriff's deputy during the attempted inspection? Yes. You represented it as a county map. It reflected county information. Rebecca enlarged the bottom right corner on the courtroom monitor. The words, illustrative exhibit, appeared in unmistakable print. The courtroom fell silent. Rebecca looked directly at Melissa. Is this an official recorded county plat? Melissa stared at the screen. No. So when you presented it as proof of ownership... Harlan jumped to his feet. Objection! Mischaracterizes the testimony. Judge Holloway looked at the exhibit. Overruled. Rebecca continued. You knew this wasn't an official plat. Melissa swallowed. I relied on documents provided by counsel. No further questions. Next came HOA President Daniel Brooks. His testimony followed the same pattern: good faith, administrative mistake, reliance on professionals. Then Rebecca asked one simple question. Mr. Brooks, before authorizing enforcement against Mr. Carter, did you ever read his deed? No. Did you review the recorded subdivision plat? No. Did you verify county parcel boundaries? No. So every enforcement action was based entirely on what someone else told you? Yes. Rebecca thanked him and sat down. Judge Holloway made several notes. For the first time all morning, Richard Harlan stopped smiling. Rebecca rose again. Your Honor, the defense calls County Survey Supervisor Michael Donovan. Donovan walked confidently to the witness stand, carrying the same weatherproof folder I'd seen the day Melissa chained my driveway. After taking the oath, Rebecca asked only one question. Mr. Donovan, based upon the official county records maintained under your supervision, she paused, has the Carter property ever been legally included within Willow Creek Estates? Donovan didn't hesitate. No. The courtroom became so quiet I could hear someone shifting in the back row. Rebecca nodded. Never? Never. She handed him the official recorded subdivision plat. He pointed directly to the western boundary. It ends here. Then he placed my deed beside it. And the Carter parcel begins here. A clean, unmistakable line separated the two. No overlap, no ambiguity, no HOA. Richard Harlan slowly stood for cross-examination, but before he could ask his first question, Rebecca reached into her evidence binder and quietly placed one final sealed envelope on the counsel table. I recognized it immediately. It contained the original developer's letter. The one admitting the HOA had no authority over my land. Harlan saw the envelope. His face lost every trace of confidence. Judge Holloway noticed the change. Ms. Lawson, she said, what is contained in that exhibit? Rebecca met the judge's eyes. Your Honor, I believe it changes this case entirely. The courtroom felt impossibly still. Judge Margaret Holloway looked from the sealed exhibit to Rebecca Lawson, then to Richard Harlan. Ms. Lawson, she said, you may proceed. Rebecca stood, broke the evidence seal, and carefully removed a single document from the envelope. Your Honor, Defense Exhibit 27 is an original letter recovered from the Williamson County Planning Commission archives. She handed copies to the bailiff, who distributed them to the judge and opposing counsel. I watched Richard Harlan's expression change the moment he began reading. The confidence he'd carried all morning disappeared. His jaw tightened. He flipped to the second page, then back to the first. Judge Holloway adjusted her glasses and silently read the highlighted paragraph. When she finished, she looked directly at Harlan. Counsel. Her voice was calm but unmistakably firm. Were you aware this document existed? Harlan hesitated. I was not, Your Honor. Rebecca stepped forward. The letter was written by the original developer to the first HOA board president before any homes were sold. She paused long enough for every person in the courtroom to focus on her. It explicitly states that the Carter parcel remained outside the recorded subdivision boundaries and that the Homeowners Association would have no authority over the property unless ownership was legally transferred. The judge looked back at Harlan. Is there any evidence before this court that such a transfer ever occurred? Harlan remained silent. After several seconds, he quietly answered, No, Your Honor. Rebecca continued, Furthermore, every county deed, every recorded plat, every tax parcel history, and the sworn testimony of the county survey supervisor confirms the exact same conclusion. She placed another binder on the podium. The association attempted to enforce covenants against land it never had legal authority to regulate. Judge Holloway slowly nodded. I've heard enough. After a brief recess, everyone returned to the courtroom. The gallery was packed even tighter than before. Word had spread through the courthouse that something extraordinary had happened. Judge Holloway entered. Everyone stood. She sat, reviewed her notes one final time, and began reading her ruling. The evidence presented leaves no genuine dispute regarding the ownership or legal status of the Carter property. She looked directly at me. Mr. Carter's parcel has never been incorporated into Willow Creek Estates. Then she looked toward the HOA table. The association possessed no authority to assess dues, issue violations, conduct inspections, place enforcement actions, or otherwise regulate the Carter property. Melissa Harper lowered her eyes. Daniel Brooks stared straight ahead without moving. Judge Holloway wasn't finished. The court further finds that the association relied upon inaccurate and misleading documents while attempting to exercise powers it did not possess. She paused. The attempted inspection, the assessment notices, and every enforcement action against Mr. Carter are hereby declared null and void. I felt years of tension leave my shoulders all at once. Rebecca gently squeezed my arm. "We're almost there," she whispered. The judge continued. The association is permanently enjoined from entering, regulating, or representing that it possesses authority over the Carter property. Then came the sentence no one in the courtroom expected. Based upon the evidence presented regarding the altered illustrative exhibit and other discrepancies, this matter is referred to the district attorney for review of any potential civil or criminal violations. A gasp swept through the gallery. Melissa closed her eyes. Richard Harlan slowly removed his glasses. Nobody spoke. Outside the courthouse, reporters surrounded the front steps before we even reached the sidewalk. Microphones appeared from every direction. "Carter! Mr. Carter! How does it feel to win? Do you believe the HOA intentionally targeted your property?" I looked at Rebecca. She nodded once. I stepped toward the cameras. This case was never about refusing to follow reasonable rules. I held up my grandfather's original deed. It was about protecting property that has belonged to my family for generations. One reporter asked, "Do you have any message for other homeowners?" "I do." I looked directly into the nearest camera. "Read your deeds. Read your county records. Never assume someone has authority simply because they say they do." The reporters scribbled notes as camera shutters clicked non-stop. Within days, the story spread far beyond Williamson County. Local television stations covered the ruling. Regional newspapers published front-page articles. Property rights organizations requested copies of the court opinion. Even several attorneys contacted Rebecca, saying they planned to use the decision as a teaching example for HOA governance and boundary disputes. Inside Willow Creek Estates, the reaction was immediate. Residents demanded answers. Emergency board meetings stretched late into the night. Several homeowners openly questioned why thousands of dollars in association funds had been spent pursuing land the HOA never legally controlled. Within 2 months, Melissa Harper resigned. Daniel Brooks stepped down shortly afterward. The association's insurance carrier reportedly opened its own investigation into the litigation expenses and enforcement practices. Several homeowners later filed a separate civil action against the former board, alleging they had been misled about how association funds were used. I wasn't part of that lawsuit. I didn't need to be. Justice had already been served. A week after the ruling, I stood beside the old white oak in my front yard. The tire swing still hung from the same sturdy branch where my mother had pushed me as a little boy. The steel chain that had once blocked my driveway was gone. So were the warning notices. So were the unauthorized survey stakes. The only sounds were the wind moving through the trees and birds returning to the pasture. Rebecca pulled into the driveway, carrying a small cardboard box. "What have you got there?" I asked. She smiled. "My favorite part of the case." Inside were every original HOA violation notice, neatly bundled together. Across the top of the stack, Someone at the clerk's office had stamped them in bold red ink. Void. I laughed for the first time in months, not because the paperwork mattered anymore, but because my grandfather had always said something that finally made perfect sense. The truth doesn't need to shout, it only needs the chance to be heard. That day, the truth had finally been heard, and it ensured that my family's land would remain exactly what it had always been. Ours. Several months have passed since the judge's ruling, and life has finally returned to what it should have been all along. Every morning, I still drink my coffee on the front porch, while the sun rises over the pasture. The old red barn still stands exactly where my grandfather built it in 1952. The workshop is busy again, and the only vehicles coming down my gravel driveway are friends, clients, and neighbors who asked permission before entering. The biggest difference isn't the property, it's the peace. No violation notices taped to my gate, no strangers measuring my fences, no letters demanding money I never owed. Just the quiet confidence that comes from knowing the truth prevailed. Oddly enough, a few families from Willow Creek Estates have stopped by to apologize. They admitted they believed everything the HOA told them and never imagined the board could be so wrong. I never held that against them. Most people simply trusted the people who claimed to be in charge. If this experience taught me anything, it's that confidence is not the same as authority. Someone can wear a badge, carry a clipboard, or speak with absolute certainty and still be completely wrong. That's why facts, official records, and the rule of law matter so much. When emotions run high, documents tell the real story. Thank you for spending your time with me and following this journey from beginning to end. I truly appreciate every one of you. Now I'd love to hear from you. Have you ever dealt with an HOA, neighbor, or local authority that tried to overstep its legal boundaries? How did you handle it? Share your experience in the comments. I read as many as I can. If you enjoyed this story, please like, subscribe, and turn on notifications so you never miss another real estate and property rights story. Until next time, take care of the place you call home, and never be afraid to stand up for what's right.